So good evening to anybody who's joining us for the first time tonight. My name is Jason Kleen. I'm an Assistant Executive Director with the Department of Cannabis Regulation. And thank you to everybody who's been with us for the last several hours. We're going to start covering part 4 of our Licensing 101 presentation. So welcome. As part of this module, we're going to go ahead and talk about the annual licensing process that will open up on Monday, May 1st of 2023. We will also be going over the California Environmental Quality Act and the local process for reviewing your environmental documents, which will lead us into a discussion of DCR Form 4013, which is our environmental review document. We'll talk briefly about using ZIMAS, which has information that you could utilize to fill out your 4013 form. We will talk about the equity share review, which will be important for phase 2 applicants that have not previously been required to go through the equity share review. You will have to go through that review before your annual license application is deemed complete. For Tier 3 phase 2 applicants, you will have to enter into a social equity agreement with the city prior to your annual application being deemed complete, and I'll share more information on that later. Then, of course, we'll have a brief discussion of the fees. I do want to highlight the fact that the city secured a significant grant from the state of California to help transition local applicants and licensees into annual licensure, and the local jurisdiction assistance grant has been providing fee waivers for the environmental review, and we will begin providing fee waivers for the annual application fees as we transition all of our existing applicants and licensees into the annual application process. So for the businesses that are in our pipeline, all businesses, general and social equity applicant, you will be eligible for the environmental review fee to cover the review of your Form 4013, as well as the annual application fees, which we discussed earlier. And then, of course, we'll continue to provide fee waivers for those two items utilizing the LJAG grant until we fully exhausted the funding from the grant. We do have sufficient funds right now to cover everybody currently in our pipeline, including the folks that are part of the phase 3 retail round 2, and monies have been earmarked for everybody who has submitted an application or been authorized to submit an application up through phase 3 retail round 2. And again, we will have some grant funding for new applicants and folks that come into the process at a later date, but we will cease providing fee waivers once those monies have been exhausted. We'll cover some of the SEP resources. Given the fact that annual licensure is a new process, this is something that Dr. Brown and her team will be starting to build out from scratch as we release information and procedures bulletins, as we release updated forms, and then as we as the licensing team start to work with her vendors on what these processes are and how the vendors can be of assistance to our social equity applicants. And then, of course, we'll briefly cover the state and DCR deadlines. We'll get into a little bit more conversation about like the operating and permits and the renewal of the temporary approval applications. And then we'll jump into the question and answer session. Again, this is just a brief overview of what activities we're accepting applications for. This will be exactly the same for the annual application process when it opens up on Monday, May 1st. New applicants will be able to apply for the non-volatile manufacturing license types, the distribution license types, the testing lab. Social equity individual applicants may be able to apply for non-storefront delivery, as well as the cultivation processor and nursery activities. And then phase 3 retail round 2 applicants, or the social equity individual applicants selected to participate in phase 3 retail round 2 that haven't already submitted their temporary approval application records will be able to submit their annual application for the retail storefront activity. For all existing applicants and licensees, so you either have a pending temporary approval application or you have a temporary approval, which is your temporary license, those folks will automatically be transitioned into the annual application process, and we'll be working with Excella to create your annual license record so that you can pursue annual licensure. And the core number for your record will remain the same. You'll just have you'll have a completely separate record for your annual license application. It'll have new suffixes which will differentiate it from the temporary approval process. For folks that have temporary approval, of course, you'll be able to continue to renew your temporary approval while you work towards annual licensure. And ultimately, once you qualify for and are issued your local operating permit on your annual license, you'll no longer have to renew your temporary approval. So we'll talk about that a little bit more in depth later on. So who's going to be affected by the transition to the annual licensing process? The simple answer is everybody. So our current license holders are going to have to transition to annual licensure, both at the local and state level, if they intend to continue operating after the state sunsets the ability to renew provisional licenses. For anybody who does not currently have a provisional license, you'll only be able to operate once you've received both your local annual license as well as your state annual license and met other permitting requirements. For folks that are in the application queue that are unable to get to temporary approval or who have their temporary approval application deemed abandoned and have to refile, you're going to have to go through the annual application process, especially if you are unable to get a provisional license prior to June 30th of this year from the state. For folks selected through Phase 3 Retail Round 2 and the application lottery, you're going to ultimately need to go through the annual licensing process. For the 30 folks that have already started the application process, you'll be able to continue to pursue temporary approval. And if you're successful in getting your state provisional license by June 30th of 2023, DCR will be positioned to issue you temporary approval as well. And if you're unable to get your state provisional license, you'll have the ability to immediately focus your attention on your local annual license application, because you'll need to complete that process and get your annual license before you can meet the state's annual licensing requirements. And then, of course, for our existing legacy operators, the existing medical marijuana dispensaries that were allowed to, for a temporary period of time, operate in a non-compliant location, such as an MR zone, based on LAMC 10407, and then the limited grandfathering provided by LAMC 105. It'll be important for you to be able to complete your annual license and get your state annual license based on your existing location, because ultimately, if at a later date you decide to relocate to a compliant location, which you'll need to do before the sunset date of the grandfathering, it's going to be easier for you to relocate a state annual license, because the state, of course, does not allow for the relocation of provisional licenses, and you can no longer apply for a new provisional license. So it'll be important for you to go through this process so that, if you do need to move your annual license, the state has the ability to relocate an annual license and apply the environmental findings that were applied to the original license to the new proposed location potentially. So those are some important things. So additional information is going to be coming out of the department over the next several weeks. And all of that information that's been released will be available on DCR's website in early May 2023, if not sooner. There's going to be two different processes for businesses going through the annual licensing process. One set of processes are going to be directly tied to retail storefront and then micro business with on-site sales. This license type has to be approved by the Cannabis Regulation Commission. There's also different noticing and public hearing requirements. So that's what we're going to focus a little bit on first. So as folks know, after phase one, which was the existing medical marijuana dispensaries, council had adopted a policy that limited applications for the type 10 retail storefront activity to social equity applicants through January 1st of 2025. So our existing medical marijuana dispensaries and our social equity applicants that have received temporary approval are going to be prioritized for the retail storefront with on-site sales because they will have to go through the additional steps and hearings in order to get through the Cannabis Regulation Commission. We have requested a complete list of the expiration dates for all licensees that'll happen on or after July 1st of this year. Beginning July 1st, the state will be requiring folks seeking to renew their provisional licenses. They'll need an updated environmental document. And in order to issue that document, you need to have submitted your Form 4013 to the department so that we can basically complete our environmental review, and we can post our draft environmental findings to the website for public comment. And once we've done that, we can issue you a letter that will then allow for you to provide evidence to the state to meet the updated requirements as part of the renewal for a state provisional license. For our non-retail and our delivery retail businesses, we'll also be prioritizing the review of any of the forms for applicants that will have state provisional licenses expire in early July so that you can have the documentation ready, and we'll begin to issue those letters in May. But we do need to have a completed Form 4013 on file, and we need to be able to review that before we can issue you those letters. So if you haven't already submitted your 4013, get it into us as soon as possible. And again, once your annual license application has been established in early May, you'll have the opportunity to upload the Form 4013 directly to that record as well. So as we're reviewing applications, we have the ability to deny the issuance of an annual license with no hearing at any time during the application process. Ultimately, if DCR determines that the applicant is ineligible for annual licensure, we'll deny the application at the earliest possible state. You do have the ability to appeal the department's determination by going through the appeal process if we deny your annual application. Alternatively, within 90 days of the date that we send out the notice of complete application, we have to make a recommendation to the commission to issue an annual license. So effectively, if you've submitted all of the forms and documents necessary and you meet all of the requirements articulated within the code, within 90 days of DCR making that determination that your application is complete, which also includes completing the environmental review, we are required to make a recommendation to the commission. So there, certain activity types like retail storefront do require a stakeholder meeting, which is effectively a community meeting. The commission hearing that you're ultimately scheduled for does have to be publicly noticed. So there's different noticing and meeting requirements that we're folding into our internal operating timeline to try to get you to the first level decision maker as soon as possible. And as we move closer to the May launch of the annual application process, we're going to be providing more information on what those timelines look like. We're going to be accepting annual license applications from the following parties. Under current law, we couldn't even begin the environmental review until a business received temporary approval. So there's certain businesses, maybe a couple dozen, that have already submitted their 4013 forms. We've already waived the fees using the LJAG grants, and we've been doing the analysis, and we're going to be positioned to post the draft findings in early May for those applicants. And then there's hundreds of other businesses that have temporary approval that were eligible to submit the 4013 form and begin the environmental process that haven't done that. So again, everybody is going to be automatically routed into the annual licensing process. And you will have to upload your previously submitted 4013 form or your 4013 form for the first time so that we can begin that review and analysis, because it will be critical for you to get that analysis completed so that you can have a complete annual application locally, and we can post our draft findings to the DCR website so that we can give you the letter necessary to renew your state provisional license. And then of course, anybody who has received a pre-application review record that was deemed eligible for further processing will be eligible to start submitting annual license applications on or after Monday, May 1st. So there may be some folks that want to continue to submit the temporary approval applications because they're in the state's pipeline to get a new provisional license. But for everybody else, it'll be to your benefit to just go directly into the annual licensing process and begin to submit everything necessary for an annual license. And then again, I just want to reiterate that the fee associated with reviewing the 4013 form, as well as the annual application fees, are going to be waived utilizing the LJAG grants. So the sooner you get your records submitted and you get the documents uploaded, the sooner we can apply the fee waiver to ensure that you get the fees waived, because we will be oversubscribed either later this year or early next year for the fee waiver programs. I anticipate that we're going to exhaust somewhere between 15 and 17 million of the $22 million we've been allotted just based on our existing pipeline once we get those annual license records created and people start to upload the documents and we start applying the fee waivers. 3 million of our monies are dedicated to the environmental review. So there's only going to be $2 to $4 million of application fee waivers that will be available beyond our existing pipeline. So this is one of those things where it's to your benefit to get in early so that you can get the fee waiver. And it's also to your benefit to get in early because you're going to have to get this annual license and get your adopted environmental document in order to get your state annual license. You know, the code requires that the annual application fees be paid within 30 days. For everybody who is an early adopter of the annual license application process, you're not going to have to worry about this because your fees will be waived utilizing the LJAG. So I don't anticipate any of these annual license applications are going to be abandoned due to non-payment of fees because we will be applying those fee waivers. However, your annual license application can be deemed abandoned if you fail to submit the requested information, documents, and forms that are required as part of our process. One of the big changes that was recently adopted by council and will be reflected in an upcoming ordinance amendment is the establishment of an operating permit. So under the existing code, businesses were required to pass a final inspection and meet all of the permitting requirements before DCR could even issue the annual license. And, you know, a lot of businesses are either working with building and safety or the fire department or water and power or the public health department on the necessary permits that they have to pull. And that requiring people to meet those requirements before we can make a licensing determination. And those are things that are all outside of DCR's control and we have no say in, just prevents us from moving our process forward, and it negatively impacts the business's ability to apply for and meet the state's annual licensing requirements. So earlier this year, the City Council adopted several recommendations to refine our annual licensing process. And one of the big pieces was giving DCR the authority to complete the review of the things that are under DCR's control and purview, be able to make the recommendation to the first level decision maker so that we could adopt the recommendation to issue a license and the environmental document associated with that discretionary action earlier in the process so that folks can meet the state annual licensing requirements earlier in the process. And then, of course, once you've been issued a local annual license, you have peace of mind that once you get your state annual license and you're able to meet those ministerial permitting requirements from those other agencies, you'll be eligible to request a final inspection. And if you pass your final inspection, DCR will issue the operating permit, which will allow for you to utilize your annual license. For businesses that hold an active temporary approval, you'll be able to continue to renew your temporary approval so that you can continue operating under that temporary approval while you work towards getting your state annual license, meeting the different permitting requirements necessary for a final inspection, and the issuance of an operating permit. So every business that has temporary approval will have two active records. One will be the temporary approval record, which will have to be renewed so that the business can continue operating. And then separately, you will have an annual license record, and you will be able to issue an annual license so that you can get your state annual license and then, invest any monies on tenant improvements or anything else necessary to meet the ministerial permitting requirements required by Building and Safety, Fire, DWP, the Department of Public Health, and others, after you have peace of mind that you've received your annual license. And then, of course, once you've got all of the necessary permits and licenses, you have the ability to request your final inspection. And then when you pass it, you get your operating permit. One of the big things is going to be other recommendations adopted by council are going to make it easier for you to relocate an annual license. And again, the state has a process that will allow for the easier transition of an annual license to a new location. So getting a local annual license and a state annual license will be beneficial to the business. Part of the amendments council adopted was allowing for the license to be sold separate and apart from the entity that it was issued to. That's one of the reasons why we've established this new operating permit. Think of the annual license as an asset that could be bought or sold. Once we've determined that the license can be transferred to another entity that meets whatever requirements have to be met, that entity has a license, but they're not going to be able to operate under that license until they are issued an operating permit. And that's the city's way of ensuring that the holder of the license has all of the necessary permits and licenses in order to lawfully operate. But the benefit to being able to use the annual license as collateral, which you haven't been able to do in the past because licenses were not transferable separate and apart from the entity that it was issued to, which is why when you requested an entity substitution, the entity that you were trying to substitute in had to submit a brand new application and go through the application process themselves and demonstrate that they meet the requirements to be licensed. And then you, as the existing licensee, would cancel your license in order for that other entity to receive their license. This process that council, or the recommendations that DCR put out there that council adopted, will make it easier for licenses to move between entities and for us to do those modifications, as well as allow for those licenses to move to different locations, and then for that business entity to move the license there and just have to meet the operating permit requirements to begin to operate at that location. So again, there are a number of substantial changes that the director worked with policymakers to push through that she's been working on for almost a year now, that were adopted in February. And I do anticipate that ordinance will be released by the city attorney's office in the next month or so that we can get those amendments dumped into the municipal code and have them become law. For the operating permit, the licensee needs to pass a final inspection, which we discussed. They need to submit through the DCR licensing portal evidence of the necessary permits, licenses, and other authorizations required by law from, city, state, or other public agencies. The most common ones are going to be building permits or fire permits, public health permits, copy of your state annual license. You'll have to make sure that your certificate of occupancy matches with the activities that you're engaged in. Building and safety is the lead for that process. They also have a clearance process with other departments such as fire and DWP, so that when the certificate of occupancy is being updated, they're routing information to these other agencies to determine whether or not any permits are necessary to do that certificate of occupancy change. All businesses are going to need a permit from the Los Angeles County Department of Public Health. Any business that has on-site retail sales will additionally have to meet the emblem requirements articulated in the code, which also comes through the County Department of Public Health. And of course, you'll have to have your corresponding state license for each of your commercial cannabis activities issued by the Department of Cannabis Control. There's always been a lot of questions about CEQA and what the city has been doing to comply with CEQA. The city has worked really closely with the Department of Cannabis Control to ensure that local applicants and licensees have had the necessary local documents in order to keep moving along in the state's process. At the local level, the environmental document required under CEQA cannot be adopted separate and apart from the discretionary action, which is the issuance of the annual license. So under the original code, you had to get temporary approval for DCR to begin the environmental review. You had to complete the environmental review and then submit all of the necessary annual documents before we could make a determination of completeness. And then once we'd done that, we would have to invoice you and wait for you to pay the fees before we could start the formal annual application process and review. So the old process was not business friendly. It was not going to expedite the transition of provisional licensees to annual licensure. So again, the director worked with policymakers to streamline that process and make it more accessible by shifting some of the requirements around. The requirements are still ultimately going to be the requirements before people can operate under the annual license. However, the order of operation has been shifted so that DCR can focus on things that are under DCR's purview, including the environmental review document, and get those adopted by the first level decision makers so that you can meet the state's licensing requirements. And then of course, once you've been issued your annual license application, if you're not already working with building and safety and fire and public health on the necessary permits, you should be, because they'll be required for that final inspection to get the operating permit. As I mentioned earlier, the submittal of the 4013 form is necessary for us to do our environmental review of your project. And for folks that are going to be renewing provisional licenses, you'll have to demonstrate progress towards your environmental compliance, and you'll have to get a letter from the city stating that we've drafted our environmental review document. And we can only do that if you've submitted your 4013 form and we've actually reviewed it and made a determination on what type of environmental document needs to be prepared. To date, all of the environmental documents I've reviewed, I believe have qualified for a categorical exemption, and that is going to be part of the department's draft analysis. But again, I've only seen a few dozen of these forms come through, so I know that there's hundreds more that need to be submitted. And for folks that do have active provisional licenses, you will have to go through this local land use review in order for us to give you the document necessary for you to renew that provisional license. And the need for that document kicks in July 1st of 2023. So we've been in direct contact with all of the bureau chiefs up at the Department of Cannabis Control And they're going to be providing us a list of when state provisional licenses are going to be expiring so that we could prioritize the review of the environmental documents necessary for folks that will be having their provisional licenses expire in July and August, so that we can make sure that you get the letter you need to renew your provisional license. We do need to have your 4013 on file, and it does need to be complete, and we do need to analyze it before we can issue that letter. So if you haven't already done so, get us that 4013 form if you have temporary approval, because we need to start reviewing it immediately. And there's no additional cost to submitting it us and having us do the review, because those fees are being waived through the local jurisdiction assistance grant. So please get it in. Now I'm going to go through the 4013 form. It's a project-specific information form. Effectively, it's giving us an overview of what your project is, what activities you're applying for, where your business premises is located, and whether or not you may qualify for a categorical exemption under CEQA. There's a lot of information tied to the assessor's parcel number, neighborhood council, the zoning, the specific plan area. All of this information is available on ZIMAS. And I know during the pre-application module, which was part 2 of today's presentation, I actually went into the live ZIMAS system and I showed the screens and where you can access that information. So if you missed that part, I would recommend reviewing it later on. And then just quickly, I'm gonna jump into it so you can see what that form looks like, or what the information in ZIMAS looks like and where you can find it. So within ZIMAS, I did have some of these tools popped up. When you type in a parcel location and you search by street number, street name, you'll get different information tied to the parcel. So the first address legal section will cover any of the addresses associated with the parcel. It'll have the assessor parcel number on it. The jurisdictional piece covers the community plan area, the neighborhood council, the council districts, etc. If you need to review any building permit issues, such as certificate of occupancy, you can do that here too. It'll link you through. Then you've got different information associated with the specific plan area, which is down here. Community overlay zones. You've got information about, let's see. Your additional is going to have some of the different things that may impact the review of the parcel. So is it a farmland? Is it a hazard zone? Is it a coastal zone? Is it a flood zone? Is it a hazardous waste, border zone property, etc.? So these are things that you'll want to review so you can make sure to incorporate it on your 4013 form. Your economic development area is going to have promise zones, opportunity zones, enterprise zones, the business improvement district, if any. You'll have information about whether or not it's subject to rent stabilization or anything else. We don't have rent stabilization for commercial properties in the city, so that most likely won't apply unless it's a mixed use building. And then of course, public safety is going to have the information related to the police department and the fire department that will help you fill out the form. So when we created the form, we worked with the state agencies to make sure it had the information we needed and the information that they needed our analysis to cover for their purposes. And we made sure that we could link the data sets that are requested here that the city has access to ZIMAS so that you could pull this information directly, which will make it easier for you to fill out the forms. So hopping back into the presentation, folks all know that you can get this information all out of ZIMAS. If you have questions, please feel free to reach out to DCR licensing at lacity.org, or call us on the phone during our business hours. And we do have public counter hours on Mondays and Tuesdays from 10 a.m. to 3 p.m. So we're here to answer questions and assist you in getting you through this process. As I mentioned, I did jump over to a live version of the ZIMAS to kind of walk people through the different categories. Here we've highlighted different subheaders for where you can find information to fill out the Form 4013. On the 4013 at the end of it, it does have a partial list of the different categorical exemptions and classes for those exemptions on the back. So if you believe that your project does lends itself to one of those categorical exemptions, you can go ahead and you can fill this out and you can put this information in. Even if you don't fill this section out, we'll be reviewing your project to determine if it does qualify for categorical exemptions. But it is always helpful if you, your consultant, the law firm that's providing you legal guidance takes a look at what exemptions may apply and you fill this out. Because it just gives us the ability to kind of hone in on specific things easier as part of our write-ups. When you fill out the form, you're going to identify where you're getting information. So ZIMAS, the DCR licensing map, any documents or references you or your consultants may be utilizing, you can input that information there. You'll talk about the zoning and the surrounding land uses. You know, when you looked at ZIMAS, it will show you in different colors what the different zones are. Pink is commercial, blue is manufacturing. I think residential is yellow, but don't quote me on that. But it has a table and a color scheme when you log in, and then you can kind of notate that within 700 feet or within 1,000 feet, these are the different types of uses. So a lot of the retail storefronts are in commercially zoned areas, or they're in manufacturing areas and they're engaged in other non-retail activities. But the zoning is correct, except for the grandfathered phase 1 businesses. And, you know, the project location and the types of things around that project location, at least directly adjacent to it, are typically the same types of zoning. You know, what's the general plan, the land use, the zoning, what activities are occurring outside. So, you know, all of our commercial cannabis activities have to occur indoors. But, you know, are you surrounded by commercial retail businesses? Is it a Best Buy? Is it a restaurant? What's next to you? What's down the street from you, et cetera? Really here, you're kind of describing what things are going on, including other businesses. And you may be demonstrating that other businesses right next to you are engaged in similar activities or the same activities that you are, which kind of lends itself to you're engaged in an activity that's appropriate for that location. Project size, you know, you're going to want to talk about the square footage tied to the different activities. When we look at your premises diagrams, you know, you're identifying where on the premises you're engaged in different licensed activities, how much of it is administrative or shared hallways, et cetera, but really focus on the floor area dedicated to a specific commercial cannabis activity. So for the folks that are engaged in cultivation that have stacked beds, what's the floor area of the room your stacked beds are in? I don't need the total cultivation space because that is most likely going to exceed the total floor area of your business premises identified for cultivation. You know, when you do your footprint and you're looking at your business premises diagram, the width times the length of the room for the activity is going to be your total floor area. Don't get involved with height. Don't get involved with doubling for stacked beds, et cetera. Focus on the total floor area and only the total floor area, because you don't want to overstate what your footprint is for a particular activity as it relates to this form. Generally, for the Form 4013s that I've reviewed, it's been a non-issue. But if you do have, if you are vertically integrated, you do have a bunch of activities, you're utilizing the full extent of the medium cultivation license and stuff like that. Some of those are bigger facilities. And, when we start doing the mapping and stuff, because we're mapping from a larger footprint, the radius around the building and what properties it covers is significantly larger. So we want to be able to do the accurate analysis. So please just give us what we need, nothing more. Your hours of operations, how many employees do you have? How many trips do you think you're generating per day? Where do you get your water from? Most people get water from the Department of Water and Power. For wastewater treatment facilities, by and large, that should be the Department of Public Works, Bureau of Sanitation. You'll describe the characteristics around your project site, topographic features, natural characteristics, a lot of the stuff you can get in ZIMAS, and you can kind of toggle between the different mapping layers, and then just write down a general identification of what's there. And you're also the applicant or licensee, so you know the surrounding area in your community, so you should be able to fill out these forms. And then, back here on page 7, you'll try to identify all of the permits that you're going to need. You will need licenses from the Department of Cannabis Control. You may or may not need permits from fire department or building and safety. Most of our businesses aren't going to have to get a permit from the California Department of Fish and Wildlife because they're not typed into any natural water source. Everybody's going to have to get a public health permit. You may or may not need anything from AQMD. Most people aren't dealing with anything where they would be affecting stream beds, so you won't need a stream bed alteration agreement. But again, we worked with the state on what the checklist could look like, and we threw everything at it. And building and safety is a resource as it comes to looking at the certificates of occupancy and whether or not you're going to have to change the occupancy, which could trigger the need for plan check review and additional permits. So you may want to reach out to them as well to make sure that your certificate of occupancy is consistent with the activities you're engaged in. And if not, which of these agencies are you going to have to reach out to get the permits or clearances necessary for them to update the certificate of occupancy? Because even though we don't need it for our process at this point to issue an annual license and make a recommendation, you will need to have all of that aligned in order to get your operating permit to operate on your annual license. And as I mentioned, there's a partial list of categorical exemptions. We just left the common ones that we've been seeing for the Form 4013s that we've reviewed to date. It doesn't mean that it's not an exhaustive list. There are a lot more class and category exemptions under CEQA. If you're working with a consultant or a law firm that has an expertise in CEQA, they can also direct you to other classes and categories that may qualify for that categorical exemption. Again, the social equity program is trying to promote equitable ownership and employment opportunities. There's a lot of resources that they put together to date based on the temporary approval process, the pre-application review process, et cetera. But Dr. B and her team are going to be working with my team on licensing to start to put together collateral materials and things for their vendors so that they can start putting out more collateral information through BLC, through the LMS system. We'll be working with LACPA to kind of update them on our processes. So I've got a meeting coming up with them so that their lawyers become aware of what this new process is going to look like. So that will hopefully help applicants that are participating in the low bono or the pro bono programs understand who they should be talking to before they enter into business agreements or what type of advice they should be getting, so that they can complete this process as quickly as possible. And then of course, for our phase 2 applicants, were able to get temporary approval without either meeting the equity share requirements and going through the equity share review, or executing the social equity agreement. Both of those things are required for the annual application process. So a tier 3 phase 2 applicant that has to enter into a social equity agreement with the city will have to submit that agreement and demonstrate that they've either complied with, are complying with, or will comply with their requirements to be a tier 3 applicant. And of course, our tier 1 and tier 2 phase 2 applicants who are bona fide social equity applicants will have to go through the equity share review before we can deem your annual application complete. So if you've got questions, if you're a phase 2 social equity applicant and you have questions about what your obligations are and what you have to do in order to meet the equity share provisions, the social equity team already has vendors and resources that identify that. And of course, they've got the one-on-one training assistance to help identify areas you can look at and answer questions. So even though some of the programming is going to be new and will be led by the DCR comms team and the licensing teams to begin with, as those materials are rolled out and as the municipal code is updated, Dr. B will be working directly with her vendors to get out as much program as possible as soon as possible, and then update the LMS system to provide those additional resources. And then of course, I talked about the need to meet the equity share requirements for phase 3, round 1 and on. We've been doing that equity share review before we issue temporary approval. So the folks that are in our pipeline have already been working with somebody on the equity share review. It's been completed, or they're working on getting it completed. For the application fees for the environmental review and annual application processes, as I mentioned, the LJAG grant will be providing fee waivers for the review of the Form 4013. Hopefully that will result in the identification of a categorical exemption for your application record. And then of course your annual application fee, which is a fee per activity, is also being waived utilizing those LJAGs. So as we transition and establish the annual licensing application records, we will be applying those fee waivers for all of our existing applicants and licensees. And you won't have any out of a pocket expenses directly tied to the environmental review for categorical exemption or the annual application, at least initially. But because you are receiving these fee waivers, please make sure that your documents are complete so that when we do the review, we don't have corrections or have to charge a la carte fees to have you resubmit and for DCR staff to re-review it. Because if you do get all of your ducks in a row, you make sure that everything is complete and it's concise, you won't have to pay any additional fees to get into and navigate out of this annual application process. I already covered what types of assistance is available. The deadlines are still all the same. The state only has until June 30th, 2023 to issue new provisional licenses. They're going to be allowing existing provisional licensees to continue to renew as long as you can meet the evolving environmental documentation, which does require the submission and review of the Form 4013. So if you have your provisional license expiring in July or August, please make sure you've submitted your 4013 form so that we can get it reviewed so you can get your letter from us. And then of course, after July 31st, any new application filed, whether it's a general applicant, a social equity applicant, a refiled application, will have to come in as an annual application. And until we've exhausted all of the grant monies providing the fee waivers, we still will be providing fee waivers. So for folks thinking about refiling that are not in a position to get your state provisional, you may just want to wait until May so that you can refile as an annual application and be eligible for those fee waivers from the LJAG grant. And then of course, for folks that are unable to get temporary approval or the provisional licenses, we'll already be creating your annual licensing application record. So if you aren't in a position to move forward with your temporary approval record, you could just go ahead and withdraw or abandon or cancel it and just focus solely on your annual application record, because that's really what you're going to need on a go-forward basis to meet the state's licensing requirements. Here are just some links again to the State Department of Cannabis Control's resources. And
let's go ahead and start with Anita M. What happens to an SCIA who are eligible to apply for a LA cannabis license but have not applied yet due to financial reasons, yet they still want to apply soon?
So verified social equity individual applicants still have the opportunity to submit a temporary approval application through July 31st of 2023. The temporary approval is really only going to be helpful if you're able to get a state provisional license, because you need both the state provisional plus the temporary approval, plus you need to meet the permitting requirements in order to lawfully operate. So if you can't get your state provisional license, temporary approval doesn't mean anything. And in order to get your annual license from the state, you're going to have a local annual license, and you'll have to have a completed environmental review document. So if you are a phase 3 retail round 2 applicant, the ordinance gives you up to 1 year to complete the pre-application review process. And of course, if you submit a compliant location that's deemed eligible for further processing, you get an additional year to file your application. If you have a pending temporary approval application that is later deemed abandoned or has already been deemed abandoned, the current code gives you up to 1 year to refile. And refiled records, again, start with the pre-application review process. And if that pre-application review record is deemed eligible for further processing, you have an additional year to submit your application. One of the recommendations council adopted earlier was to extend the refiling period from 1 year to 3 years, and then also allow licensees who allowed their licenses to expire to refile. So that was all done with the director's intention of giving people more time to find compliant locations, make necessary business decisions, raise capital, look for partners, do other things. So the director has really been cognizant about trying to give people as much time as possible to comply. And thankfully, policymakers adopted a lot of those DCR recommendations. And as soon as they have the opportunity to review the draft ordinance and adopt the draft ordinance, those changes will start to become local law. So there's a lot of things moving. If you can't get temporary approval, you can't get a provisional. We've tried to make the process for the annual license as streamlined, as simple as possible, before you actually have to secure a location or potentially incur any costs associated with tenant build-outs or other permitting activities.
Thanks, Jason. This next question has a few details, so if you need me to repeat it, please let me know. This one comes from Mary Jane. When making a request for modification, in this case, an ownership removal, the entity has 2 licenses at one location and 1 license at another location, all owned by the same entity. Do we submit one form with all the license numbers listed to the LBER, or do we submit one form for each license as a merged document?
So say hi to Peter Parker and Spider-Man for me. And so one of the big purposes of creating the legal business entity record is so that all of the ownership and operating related information was on one record. And then that record would be the parent of the application and licensing records, which are location specific. So if you've already created your LBER, you would just submit one modification request against your LBER. And then once we've approved that change, then those changes will be pushed down to any pending applications or licenses that have been issued so that your ownership is consistent across all of your locations and all of your activities. So the answer is one modification would be submitted against the LBER, And that would cover all of your pending applications as well as any locations that have been licensed.
Thank you, Jason. Our next question comes from Edwin A. He's having trouble finding a property that is far away from a sensitive use. Are there any resources you can provide to help us identify a suitable location for a retail location?
The big tools are going to be the DCR licensing map, as well as the zoning information map access system. And, links are in this presentation, and I've kind of walked through a few of the tools and the things to toggle on and off to help you find a compliant property. But we don't have a list of compliant properties, nor do we have a list of landlords that may be willing to lease to a commercial cannabis business that you could look at. The director is aware that a lot of social equity applicants have made it known that it's difficult to find a compliant property. And even when you do find a compliant property, finding a landlord that's willing to lease to you has been difficult. So there are some additional policy considerations that the council will be taking up, hopefully, in the next few months that may give us an idea of whether or not we could see change on the land use side. And of course, the land use side and the administration of LAMC 105 and any change to that section of the municipal code, the Department of City Planning is the lead. So we would have to propose amendments, council would have to support those amendments, and then they would have to direct the Department of City Planning to prepare and present the necessary documents to effectuate those changes. And having gone through that just to get LAMC 105 updated to clearly define the sensitive uses and when flags get planted and everything else, which we started back in 2018, it took about 2.5 years to get through that legislative process. So I don't know if it could be done faster, but once the ball gets rolling on it, it's unfortunately outside of DCR's control.
Our next question from Katie. How long are TA holders exempt from needing an operating permit in order to operate?
So we've designed our local process to allow for a temporary approval to be renewed through the 2027 license year. So no later than January 1st of 2028 would you have to have an operating permit in order to utilize your local annual license. We set it out so far, beyond what the state was doing, with the knowledge that, the state doesn't have all of the local requirements as part of their process that we do. And our goal is to get you to a decision point that's under DCR's control so that you can get to a decision point that's under the DCC's control. And then you can work with all of these other agencies that don't take input from DCR, nor do they report to DCR to get your necessary permits. So we do encourage folks to start meeting with those departments as soon as necessary. And the Form 4813 does identify a number of the agencies you may need to get a permit or a license from in order to lawfully operate and meet the requirements for a final inspection to get your operating permit. If you ask the legacy operators and the phase 3 retail round 1 folks, nobody anticipated that there was going to be a global pandemic in 2020 where departments stopped providing in-person services and things transitioned to virtual services, and there was an inability to get supplies for a number of months, if not years. There were staffing shortages and everything else. So at the earliest point you can get into a process and start to inquire what you need so that you can have everything you need to qualify for the operating permit, you really should be doing it, because we're not going to be able to further extend these timelines due to unforeseen consequences. So 2027 is the last year a temporary approval will be issued for. By January 1st, 2028, you need to have an operating permit if you want to be able to use your annual license.
Jason, I'm just checking the time. It's 7 o'clock. I think we have about 5 questions to go. Are you good?
I'm good if you are.
I am. Okay, so the next question from Katie, can a existing medical marijuana dispensary that is not an SEA renew with the state this upcoming summer if a 4013 has not been submitted to DCR?
No. So the state's requirement to renew a provisional license is a requirement for all applicants to demonstrate that their local agency has completed the initial environmental review, and we need a submitted 4013, and we need to analyze it before we can make that determination. Again, only a few dozen of these 4013s have been submitted. All of the ones that I've personally reviewed have qualified, in my mind, have qualified for a categorical exemption, and that is the draft recommendation for the department, which would go out for public comment. And once we start posting those for public comment, which we'll begin to do in May, so that folks can start getting their letters to renew after July 1st, that satisfies the state's enhanced requirement for the renewal of a provisional license. But it applies to general applicants and social equity applicants.
Rick has a question about Form 4013, specifically item 7. Do we have to submit with Form 4013 all of those items listed? Don't know if you recall what item 7 is.
Sorry, I apologize. I was talking on mute. I pulled up the 4013 form so we can walk through it together. This is a list of other federal, state, or local permits that may be required. Everybody is going to have to get a license from the Department of Cannabis Control, so that should be checked. Depending on your activities, you may or may not need to get anything from fire department or building and safety, water and power, or the Bureau of Sanitation. I would recommend reaching out first to the Department of Building and Safety based on the certificate of occupancy to find out, based on the activities you're engaged in, whether or not you're going to have to update your certificate of occupancy. If you do have to update your certificate of occupancy as part of that process, you're going to have to submit for a plan site review, and there will be a clearance process where the Department of Building and Safety will require you to get clearances from water and power, fire department, public health, et cetera, where they have an opportunity to identify whether or not a permit would need to be issued before they'll give the clearance to building and safety to update the certificate of occupancy. For the Department of Fish and Wildlife, I haven't seen any projects that would require a permit from them. There's not any projects to my knowledge that affect any stream beds or anything else. For the State Water Resources Control Board, again, all of our water goes through the Department of Water and Power, and I don't think I've seen anything that I have not personally seen anything that has required anything from the State Water Resources Control Board. Every business is going to be required to have a public health permit, so that should be checked for all of them. For the local air district, which is AQMD, I haven't seen anything come through with that. Stream bed alteration, I haven't seen anything come through with that. The water quality protection program, I haven't seen anything come through with that. But I have seen things come through with the city agencies, especially for folks working through changes to their certificate of occupancy. And again, for those types of changes, building and safety is the lead, and they have their own routing and clearance process to do those updates. So if you have questions about whether or not you're going to have to amend your certificate of occupancy, building and safety is the place to send that inquiry.
Okay, our next question from Katie. How does a TA holder know that their 4013 has been reviewed and approved by ZCR in order to get sufficient documentation to submit to DCC?
So we're going to begin to upload our draft environmental documents in May. So if you haven't seen your draft environmental document be uploaded by June 1st, I would inquire with the DCR. Again, we have requested a list of expiring provisional licenses for July and August. so that we can prioritize the review of the 4013 forms for those businesses so that they can get the letter they need to renew their provisional license. Otherwise, we're just processing things in the order received. But there are hundreds of businesses that are probably going to need to renew their provisional license over the next 6 to 12 months that have not submitted their 4013 form, that are going to be competing with everybody else that is now submitting the 4013 form as part of the annual application process, or they need to renew their state provisional license. So again, we have fee waiver monies available for doing the 4013 review. And it's just a matter of you getting the form completed and getting it into us so that we can begin the review and we can get you what you need to comply with the state.
Here's a question from Josh. For entities with temporary approval received, is there a way to file extension for the TA not to expire while the annual license is being applied and reviewed?
I'm not 100% clear on the question, but the temporary approval record and the annual license record are two separate records. And they both live on their own. So if you've received temporary approval, you'll have the ability to continue to renew your temporary approval on your temporary approval record through the end of 2027. So you could you can continue to renew your temporary approval and have it be operable through December 31st, 2027. That should give you sufficient time to work through the annual license application process, receive an annual license, get your state license, and then begin to get the any permits needed to do the final inspection and get your operating permit to utilize your annual license. For folks that get into the annual licensing process that have provisional licenses, continue to renew that temporary approval until you get that operating permit so that you can continue to operate, of course. And hopefully that provides enough information to answer the question.
Okay, and then our final question comes from Katie. Will DCR immediately revoke TA and notify DCC in order for the operator to be forced to shut down if an operating permit is not obtained by the deadline?
So it may be a semantics question, but there are certain reasons why DCR could suspend or revoke temporary approval or an annual license, and those are kind of articulated in the code. But if the operator fails to timely get an operating permit, that means that they didn't get an operating permit by January 1st of 2028, or they failed to timely renew their temporary approval, and their temporary approval just expired because they're only valid for a year to begin with. So we do share lists and information with the DCC on a periodic basis. And, a business that doesn't have an active license or an active application is not going to appear on that list. And when DCC reconciles the local data against their databases, they will identify operators that don't have a local license or authority to operate. And that could, ultimately result in some other type of enforcement action being taken against the operator. But we typically, we have not taken an action to revoke temporary approval as part of a disciplinary action against a business yet. And we wouldn't notify the state of a revocation for a disciplinary action until we knew whether or not the operator was appealing that decision and the adjudication of that appeal. Because we've had instances where the state's notified us that they've revoked a provisional license, and then we've started to take actions to revoke the temporary approval. And by the time we get to a hearing, the person has come into compliance with metric, or they've come, they've basically made any outstanding tax obligations, they've brought their tax account current, and then the state immediately reinstates their license. And now you have the license. So the reason we were seeking to suspend or revoke your temporary approval is now a non-issue. So now we kind of wait a little bit longer before we initiate those proceedings to make sure that the decision is final, so that both parties can move forward appropriately.
And that is the last question. Thank you so much, Jason.
Thank you so much for hanging out with me for the last 4.5 or 5 hours. And, thank you everybody for tuning in today. This presentation and the additional materials are going to be made available next Monday. So our systems analyst will be working on getting everything rendered and putting in the chapters in so folks can jump to different points of the presentation. That'll be available on the website with the PowerPoint presentation. And as I mentioned, we'll be launching the annual licensing process on Monday, May 1st, so that there's going to be a lot more updates and information posted as it relates to that process over the next coming weeks. So thank you everybody for tuning in today. I hope everybody has a wonderful weekend, and I look forward to our next webinar. Good night.